Mama, I need you to understand. Judge Arwell has a full docket on Tuesday. And if you walk in there without legal representation, he is going to sign the temporary guardianship order before you finish your first sentence. And the sale to those Buckhead buyers closes Friday. That's what Marcus said at 8:47 p.m. Ma'am? On Monday, April 7th, 2026. I was standing at my kitchen counter in Memphis with my hand on a manila envelope that had been growing thicker since 1991. I'm Vivienne Dolores Hargrove, 61 years old, and I spent 30 years as a school administrator, the kind of woman who keeps files, who knows the name of every building inspector who ever walked through 1404 Magnolia Drive, who can tell you why every mortgage payment mattered. The house I was standing in had been paid off by my own signature on every note for 12 straight years. Alone. What Marcus didn't understand, what none of my children understood, was that the manila envelope in my hand held Diana Castillo's retainer receipt, dated March 9th, 2026. The day Celie called me from the church parking lot and told me she'd overheard him in the hallway asking another lawyer whether Tennessee guardianship law could be used to pause a property sale. What he didn't know was that I'd already been to see Dr. Patricia Thornton, the neurologist at Mercy General, and that she'd written an assessment of my cognitive capacity dated 14 days before his phone call. Before the petition, before he even knew what he was about to do. Dr. Thornton was the woman who'd signed my husband Raymond's death certificate in February 2014. She was the woman who used to come to our Sunday dinners and let all three of my children call her Auntie Pat when they were young, and the house was full and Raymond was still alive. They hadn't seen her in years. They didn't know I still sat with her coffee with cream on a Tuesday morning, talking about memory and judgment and the difference between grief and incapacity. But at 8:47 p.m., standing in my kitchen, I let Marcus talk. I'm not trying to threaten you, Mama, he said, and I could hear him shifting into the tone he used with his clients at Mid-South Finance, the voice that suggested he was looking out for me, that he knew better, that this was for my own good. Devon and Renata, they're upset. They think the sale is too fast. They think you haven't really thought through what this means. Selling the house, leaving Memphis. Nobody's saying you're not capable, but you've been through a lot. You've been retired less than a year. The judge is just going to see someone who's grieving, who maybe isn't thinking as clearly as she normally would. I didn't interrupt him. I let him build it, brick by brick. The story he'd been working on since December. The story where my grief made me fragile. The story where my age made me vulnerable. The story where the only way for my children to prove they loved me was to take control away from me. If you don't have a lawyer, Marcus continued, it's going to look like you can't afford one. It's going to look like you're confused. And Judge Harwell won't see any reason not to sign the order. It's just protection, Mama. That's all we're trying to do. I understand. Marcus. Do you? Because I need you to really understand this. The petition gets signed by a judge. The sale falls through. And we can figure this out as a family. But if you fight us, if you make this ugly, you're going to force Devon to testify about your finances. And Renata's going to have to get into specifics about your medical situation. And all of that goes in a record that stays with you forever. Is that what you want? He was laying it out now. The threat underneath the care. He wanted me to surrender before Tuesday. He wanted me to understand that my options were cooperate or be humiliated. He wanted me to be afraid of my own son. I wasn't afraid. I was listening to the sound of his voice and calculating how long it would take him to walk into that courtroom and discover that every single advantage he thought he had was something I'd already counted. Every card he believed he was holding, I'd already seen. I'll see you Tuesday, Marcus. Mama, please, just think about it. Talk to someone, a lawyer, a doctor, someone. Just make sure you're not making a mistake. I've been making decisions about that house and about myself for a long time, I said, quiet. I'm not going to stop now. I hung up and set the phone down. The kitchen light was warm on the granite counters. The house was silent except for the ice maker running in the refrigerator. The sound it had made every night for 12 years. I took the envelope and opened it again, spreading the documents in front of me like a hand of cards. The original deed from 1991. When Raymond and I were still young enough to believe a house was just a place to raise children. Every repair receipt going back to 1997 when the roof needed replacing, and I sat in the contractor's office and signed the estimate myself. 12 years of mortgage statements in my name alone. Each one marked paid in full. Marco Reyes' current appraisal, dated March 6th, showing $387,000. I added one document to that envelope every time something changed in that house. It was my insurance policy against anyone who ever tried to tell me I didn't understand what I owned. I poured an inch of bourbon into the blue mug his father's army battalion gave him when he retired. 2 sugars. Splash of cream. The way I'd been making it for 40 years. And I sat down at the table and looked at what I'd built. December, when I first told Silly I wanted to leave Memphis, felt like a lifetime ago. That was the month I decided. I was 61 years old. I'd spent my adult life in that house. Raymond had been gone for 12 years. The children were grown. I'd paid off every cent of the mortgage myself. The house was worth more than it had ever been, and I had the right to do what I wanted with it. I'd earned that right. But December was also the month Marcus started coming around more. The month his calls became more frequent. The month he began asking about my future, my plans, whether I'd thought about what would happen to the property after I was gone. That was his word. Property. Never home. Never the place where he'd learned to tie his shoes or where he'd cried the day his father died. It was property to him because it was worth something. That's what I understood by January, when I made the call to the real estate agent and put together the list of buyers. That's what became clear in February, when Marcus asked for a loan, $67,000, just to clear some debt, just for a couple of years. And I told him no for the first time in his life. He didn't ask again. He just started looking at the house differently. Silly called that night around 10 o'clock. I'd been expecting the call. Silly had been my backup since the day I married, the kind of woman who knows your life better than you know it yourself. He contacted you, she said, not a question. He called from his car. What did you tell him? That I'd see him Tuesday. There was a long pause, and then Celie made that sound. Something between a laugh and a sigh. The sound of a woman who's been protecting you so long, she can read your mind. "You got yourself ready," she said. "I got myself ready." "And you got Diana?" "I got Diana." "And you got the doctor?" "Auntie Pat signed everything." Another pause. Then, "All right then. You want me at the courthouse?" 7:30. Parking lot. "I'll be there with coffee." We didn't talk about what was coming. Celie didn't ask me if I was scared. I didn't tell her how careful I'd been. How I'd rehearsed every moment of the last 3 weeks over and over. How I'd let my children set their own trap and then stood back and watched them walk into it. Some things don't need saying between women who've known each other since they were young. The Monday night passed the way every other night in that house had passed. I sat at the table with my hands steady. I didn't send a message to my children to warn them. I didn't call Devon back when he texted at 11:02 p.m. asking about the equity split. I'd already forwarded that text to Diana the night he sent it. And she'd smiled the small smile of a lawyer who knows exactly what she's looking at. The kind of smile that says, "I see what they're doing and it's going to fall apart in 8 minutes. The trap works best when the other side doesn't know they're walking into it. When they believe they have you, when they believe they understand the game, and you don't." Tuesday morning came the way it always did. I woke at 4:30 without an alarm. My body just knows. And I went downstairs in the dark and made the coffee. The community chicory kind I grew up drinking in Louisiana before I moved to Memphis to be with Raymond. The house was quiet. It was just me and the percolator doing its work and the sound of birds starting up outside. By 5 a.m., I had the ironing board set up in the bedroom and the dress laid out. Navy. Simple. The one I'd bought for a funeral 3 years before. Nothing that would make me look fragile. Nothing that would ask for protection. I needed to look like a woman who'd already made her peace with everything. At 5:30, I set the iron on the dress collar and let it heat. The iron clicked and settled. I pressed the collar first, then the sleeves, then the body and the hem, moving with the same rhythm I'd used 1,000 times before. Back and forth, steady, no hesitation. The steam rose up and the fabric went smooth under my hand. While I worked, I thought about the house downstairs, about the mortgage I'd paid off note by note, about the years I'd spent keeping it beautiful for children who were planning to take it from me. I thought about Raymond lying in the master bedroom those last 3 days before he died, and how I'd sat on the edge of that bed and held his hand and never once thought I couldn't do what came next. I'd buried him. I'd managed the house alone. I'd kept it paid for. I'd kept it standing. And what these children thought they knew about me was nothing compared to what I actually was. When the dress was finished, I hung it carefully on the hanger and went to the bedroom closet. I found the watch, Raymond's lapel watch, the one he wore on his military uniform, the one that kept time with military precision. Never fast, never slow. I pinned it to my jacket, small and silver against the navy wool. It was 6:15. The sun still hadn't come up. I sat on the edge of the bed and opened my Bible to Proverbs 31 and read it aloud to the empty room. The way my grandmother had taught me to do when I needed to remember who I was. Strength and honor are her clothing, And she laughs without fear of the future. She watches over the affairs of her household and does not eat the bread of idleness. Her children arise and call her blessed. I read it twice, slow, so I could feel it settle into my bones. Not my children. Not my family. Her children. The ones who rise up and see her. The ones who know the difference between love and theft. By 7:15, I was ready. I picked up the tote I'd packed the night before, the one with the manila envelope, with Diana's documents, with the 14-day-old assessment from Dr. Thornton, with everything I'd kept and counted and held onto for all these years. I looked at 1404 Magnolia Drive one more time, standing there in my navy dress with my husband's watch pinned to my chest. And I didn't feel the thing my children were afraid of. I didn't feel confused or fragile or like a woman who needed protection. I felt like a woman who'd made a choice and done the work and knew exactly what came next. I picked up my keys. I didn't look back. 1404 Magnolia Drive was never supposed to be just mine. When Raymond and I found it in September 1991, we were standing in the driveway on a Saturday morning. And the first thing I thought was, this is where we'll raise them. The house was a 3-bedroom craftsman with good bones and a porch that faced the street. And it cost $94,000. We had the down payment saved, and the bank approved the mortgage the week after Raymond showed them his employment letter from the army. He'd gotten out 2 months before. We were both ready to settle, to put down something permanent, to build a life that wasn't temporary. The house was 2 blocks from Greater Calvary Baptist Church, which meant my mother could walk there in 5 minutes if she needed to, and the children would grow up knowing the way to church by heart. Memphis was where Raymond's family had roots, where his mother had raised him, and I was ready to leave New Orleans behind. Not forget it, but not live it anymore. The house was perfect. We signed the papers, and for 34 years, we never missed a mortgage payment. Not once. Not in 1993 when Marcus was born. Not in 1995 when Devon came. Not in 1998 when Renata arrived. Not during the years when the payment stretched tight because Raymond's paycheck only went so far. Or during the month when the hot water heater burst and I had to choose between fixing it and paying the electric. We made every single payment on time. Those early years, the house was alive in the way houses are when children are small. There was noise, the kind of noise that fills every room, that echoes in the hallway, that you can still hear when you step outside. Raymond coached Marcus in the driveway, teaching him to hold a baseball bat, and I could hear them from the kitchen window. I taught Devon to read at the kitchen table under the morning light, moving my finger under the words while he sounded them out. Patient. Renata learned to walk on those wooden floors, holding onto the couch, letting go for 3 steps before she fell, trying again. We hosted Thanksgiving dinner for people who had nowhere else to go. And my mother came over on Sundays and made greens in my kitchen with her hands moving the way her mother had taught her. She'd saute them in bacon grease with a pinch of sugar. And the smell of them would travel through the whole house. The house held all of it. It held us. By the time Raymond got sick, in early 2014, the house was 23 years old and paid down to something manageable. He spent his last 3 days in the master bedroom upstairs. I sat on the edge of that bed and held his hand. And I remember thinking, this house knows what's about to happen. Houses know things. They feel the change in the air before anyone else does. Raymond died on February 18th, 2014. I was 52 years old. The children were grown. Marcus was already working at Mid-South Finance. Devon was teaching middle school. Renata was out of the house and building her career. It was just me left to manage the mortgage, the taxes, the repairs, the insurance, everything that a house requires to keep standing. I learned fast. I learned which contractor wasn't going to overcharge me just because I was a widow. I learned how to read an estimate, how to say no, how to compare quotes. I learned that the roof had maybe 5 more years in it, so I started setting money aside. I learned that the foundation was solid. The inspection report from 1991 had noted that clearly. And I kept every piece of paper from that first sale. I learned to manage a complex financial asset alone, which is something I'd had the luxury of not worrying about before. Raymond had handled those things. I'd handled the house itself, the living in it, the making it a home. Now I did both. There was no one else to call. There was no backup. When the pipe burst under the kitchen sink in 2016, I was the one who had to decide whether to call a plumber or try to fix it myself. When the gutter came loose in 2018, I was the one who had to decide whether it could wait or whether it needed immediate attention. When the property taxes went up, I was the one who had to figure out how to absorb the increase into my budget. For 12 years, from February 2014 to 2026, every decision was mine. For 12 years, I paid that mortgage myself, alone, every single month, even when times were tight, even when it would have been easier to call one of the children and ask them to help. I didn't ask. This was my responsibility, my choice, my house to manage. I kept meticulous records. I saved every mortgage statement in a folder, labeled them by year. I kept the original deed in a file. I kept the inspection report from 1991. Raymond's handwriting was all over it. Notes about the condition of the roof, the age of the foundation, observations he'd made that afternoon. And I never threw it away. Every time something was repaired, I kept the receipt. When I had the property appraised in 1997, I kept that appraisal. When I had it appraised again in 2008, I kept that one too. By the time I decided to sell, I had a complete history of that house from purchase to present, documented in a way that would make an accountant weep. In January 2026, after I retired, I made the decision. I was 61 years old. I'd spent my adult life in Memphis. I'd spent my adult life in that house. 35 years. 34 of them as an owner, a manager, a woman responsible for every decision about that building. I'd done the work. I'd kept it paid for. I'd kept it maintained. I'd kept it standing. And I was ready to leave. Savannah had always called to me. The light there is different, softer. The way light is in the south when it comes through moss and water. I had a friend there from college who'd moved down in the 90s, and we'd kept in touch. She kept saying, "Come! You don't have to stay in Memphis forever. You've done what you were supposed to do. Now do something for you." I'd always said maybe, not now, not yet, but retirement changed that calculation. There was no job keeping me in Memphis. There were no grandchildren yet. The house was paid off. The children were launched. The only thing keeping me there was inertia and habit, and the weight of a life I'd built so carefully that walking away from it felt like betraying something. It wasn't. I understood that by January. Leaving the house wasn't abandoning it. It was honoring the work I'd done there by trusting that someone else would care for it the way I had. The house had served its purpose. It had been a good foundation. Now it could be someone else's foundation. I called a real estate agent in early March. His name was Marco Reyes, and he came out and walked through the house with the eye of someone who understood what he was looking at. He spent 45 minutes in there, upstairs and down, checking the fixtures, looking at the roof from the porch, noting the age of the furnace, the condition of the plumbing. He had a clipboard and he made notes. At the end, he told me the house was worth $387,000. That was his appraisal. $387,000. I'd bought it for $94,000 in 1991. That house had nearly quadrupled in value over 34 years. I'd managed that asset. I'd done the maintenance, but I'd kept it sound. Every dollar of that increase was work I'd done. The appraisal was dated March 6th, 2026. 3 days later, on March 9th, I called Diana Castillo's law office and paid her a $3,500 retainer. 2 weeks after that, my children filed a petition to take it away from me. But before any of that, before the decision to sell, before the appraisal, before the lawyer, there was the filing cabinet. I kept a manila envelope in the drawer of my filing cabinet. The one in the office that used to be Raymond's study and became mine after he died. The envelope was labelled House in black marker, and it had been there since 1991. It started with the deed and the inspection report. Over the years, it grew. Every repair receipt went in there. Every mortgage statement went in there. When I had the appraisal done in 1997, I put that in there. When I had it done in 2008, I put that in there too. Every time I paid off a portion of the principal, I kept the bank statement that showed it. Every time the property taxes changed, I kept the notice. Every time the insurance company adjusted my premium, I kept the letter. The envelope was my chronicle. It was my proof. It was my record of stewardship. On the evening of March 21st, 2026, the night Devon sent me that text message about the equity split, I went to that filing cabinet drawer and I pulled out the envelope. My hands knew exactly where it was. I'd added to it so many times over the decades that reaching for it was like reaching for something I'd touched 1,000 times before. I spread the contents across my desk. The deed, Raymond's handwriting on the 1991 inspection, 34 years of mortgage history, the appraisals, the repair receipts, organised by year, Marco Reyes's 3-page report, dated March 6th, showing the current value at $387,000. 12 years of mortgage statements from 2014 to 2026. Every one of them in my name alone. Every one of them paid in full. I sat there looking at what I'd accumulated, at the evidence of what I'd built and maintained and protected. I looked at all of it, and I understood what I was holding. This wasn't just paperwork. This was evidence. This was a record of what one woman alone could do with a financial responsibility. This was proof that I understood what I owned. This was the documentation that would prove, in a courtroom, that a woman who had managed a $94,000 investment into a $387,000 asset alone for 12 years was not incapable of understanding financial decisions. I called Diana Castillo at her home that night. She'd given me her number, and I told her to come by in the morning. We sat at the kitchen table with the envelope open between us, and Diana looked at the documents one by one, and her expression didn't change, but her eyes kept moving faster. She read Marco Reyes's appraisal. She looked at the mortgage statements. She paged through the repair receipts, organized by year. She held Raymond's inspection report from 1991 in her hands for a long moment. "How long have you been managing this property alone?" she asked. "Since my husband died in February 2014, I said. 12 years. And you've kept every document since the purchase. Everyone. Every mortgage statement. 12 years worth. All of them." Diana set the papers down and looked at me. "The petition claims you're incapable of understanding complex financial transactions," she said. "These documents are going to make that claim look like fiction." I put the papers back in the envelope carefully, sliding each document into place. I felt the weight of it in my hands. Not heavy in pounds, but heavy in what it meant. That envelope held 34 years of my life. It held the proof of what I'd chosen to do. It held the record of a woman who paid attention, who kept her promises, who understood what she owned, and who managed it alone. It was insurance. It was protection. It was the thing that would save me. I placed it on the table between us. "This is what they're going to see," I said. Diana nodded. "This is what they're going to see," she agreed. On the morning of April 8th, I took that envelope with me to the courthouse. The documents were going to speak for me in ways that words never could. The house on Magnolia Drive had been a home. Yes, it had been the place where my children grew. It had been the stage where my life with Raymond played out. But more than that, it was proof. It was proof that I understood what I owned. It was proof that I could manage what I chose to manage. It was proof that for 12 years, alone, I had made every decision correctly. The house on Magnolia Drive was my competence made visible. And that's what the court was going to see. The process server arrived at 1404 Magnolia Drive at 9:14. On Thursday, March 23rd, 2026, I was in the kitchen making breakfast. Scrambled eggs with butter and salt, wheat toast, a glass of orange juice. When the doorbell rang, I didn't know what it was yet. I just knew someone was at my door. I went to answer it. A woman in a navy blazer was standing on my porch holding a manila envelope, and she asked if I was Vivienne Dolores Hargrove. I said I would. She handed me the envelope and said, "You've been served." And then she turned and walked back to her car. I watched her drive away. Then I went back inside and finished my eggs. I sat down at the kitchen table and ate them slowly, tasting the butter, tasting the salt, letting the moment settle before I opened the envelope. The morning light was coming through the window. I could hear the neighbors' children on the street. Everything was exactly the same as it had been 2 minutes before. Then I opened it. It was a petition, 5 pages, certified, notarized, signed by all 3 of my children, Marcus Antoine Hargrove, Devon Charles Hargrove, and Renata Joy Hargrove. They were petitioning the Circuit Court of Shelby County, Tennessee, for a limited guardianship over their mother. Me, on the grounds that I was no longer capable of understanding the nature of complex financial transactions, and was vulnerable to undue influence by outside parties in connection with the proposed sale of my property. The petition requested that the court appoint a guardian to approve or deny any financial transactions I undertook. It also requested that the sale to the Buckhead buyers be blocked pending a determination of my capacity. I read it twice. The language was clinical, measured. It sounded like concern. It sounded like protection. The kind of language that makes theft sound like care. They weren't trying to steal my house. They were trying to protect me from myself. They weren't trying to block a sale. They were trying to save me from undue influence. Every sentence was built to make their actions sound reasonable, even noble. The petition claimed that I had become confused about financial matters. It suggested that outside parties, the real estate agent, presumably, or the Buckhead buyers, were taking advantage of my age and my grief. It presented my decision to sell as evidence of incapacity, rather than as the deliberate, considered choice of a woman who had thought about it carefully and decided she was ready to leave Memphis. The petition never mentioned that I'd managed a property alone for 12 years. It never mentioned that I had an appraisal. It never mentioned that I'd talked to a lawyer about the sale. It never mentioned any of the things that proved I understood exactly what I was doing. Instead, it listed symptoms of cognitive decline that I did not have: disorientation, confusion about the value of assets, an inability to understand the consequences of financial decisions. Language designed to paint a picture of a woman who had lost her grip on reality. I set the petition down on the table. My hands were steady. I didn't feel shock. I didn't feel betrayal. Not yet. What I felt was confirmation. I'd been expecting this since February, when Celie told me she'd overheard Marcus asking another lawyer about Tennessee guardianship law. I'd been waiting for this since January, when I decided to sell. I'd been preparing for this since March 9th, when I paid Diana Castillo's retainer. The petition was the thing I'd been waiting for. The proof. The confession. I called Celie at 10:15. I need you, I said. Come by this afternoon. She arrived at 1:30 p.m. and I had the petition laid out on the kitchen table like evidence in a crime scene. I poured her coffee, the chicory kind, dark, the way she liked it, and I handed her the papers. She read through them slowly, her reading glasses sitting on the bridge of her nose, her mouth getting tighter as she turned the pages. When she finished, she set them down and looked at me. Her expression was careful, controlled, the way a woman looks when she's trying not to show her anger. They filed this, she said. This morning, our process server brought it. On what grounds? That I can't understand financial decisions. That I'm being influenced by outside people. The Buckhead buyers. I assume someone is supposedly telling me what to do with my own house. Celie picked up the petition and found the phrase. She read it aloud. No longer capable of understanding the nature of complex financial transactions. She looked at me over the rim of her glasses. That's a lie. Yes, I said. You managed that house alone for 12 years. I did. You kept every receipt. You got it appraised. You hired a real estate agent and negotiated the terms. I did all of that. They can't prove any of this, Celie said, tapping the petition. They have no doctor's report. They have no evidence of anything except that you made a decision they don't agree with. They have their fear, I said. Marcus is in debt. $67,000 in personal debt. He's looked at what my house is worth, and he's done the math about what his share would be. Devon borrowed $23,000 from me in 2021 and never paid it back. He's worried I'm going to ask for it when I leave Memphis. Renata is grieving. She thinks the house is her father somehow, but none of that is in the petition. The petition says I'm incapable. That's what they think they can prove. Celie looked at the papers again. She turned them over, looking at the signatures. Marcus had signed first, then Devon, then Renata, 3 children signing their names to a lie. And for what? For money, for grief, for the belief that they had a right to their mother's choices. When did you know they were planning this? Celie asked. Devon texted me on March 21st at 11:02 p.m. I said, he asked about the equity split. He said Marcus said they were all entitled to weigh in before I signed anything with the Buckhead buyers. That text was the tell. That's when I knew it was happening. What did you do? I got up and went to the counter and made a full pot of coffee. I used the real chicory, not the imitation blend. I let it brew slowly, and the smell of it filled the kitchen. Heavy, dark, authentic. It was the kind of smell that settles in and reminds you of who you are and where you came from. While it brewed, I told her exactly what I'd done. On the night of March 21st, when Devon's text came in at 11:02 p. Oh. I screenshotted it. I held my phone and took a photograph of his message on the screen. His exact words. His exact time. Then I forwarded that screenshot to Diana Castillo at 11:47 p.m. That same night, along with a message that said, "They're moving," Diana wrote back at 12:03 a.m. Friday morning. Got it? See you Friday morning. That was March 22nd. That was the morning before the petition was served on my doorstep. I poured the coffee into 2 cups. I set one in front of Celie and kept one for myself. The steam rose up between us. So they don't know, Celie said. It wasn't a question. They don't know, I confirmed. They think I'm unrepresented. They think I'm confused. They think I don't understand what's happening. They think they caught me off guard. But you knew. I knew. I've known since February when you told me about Marcus asking that lawyer. I've been planning for this for 6 weeks. Celie picked up the petition and set it down again. Like it was something contagious. What did Diana say when you showed her the text? She said it was perfect. She said the text proves financial motive. Devon asking about the equity split. She said the timing of the petition, 2 days after the text, proves coordination. She said the claims in the petition are going to be easy to demolish because they're claims about my cognitive capacity. And she has a neurologist assessment dated before the petition was even filed. You saw a neurologist? On March 18th, Dr. Patricia Thornton. She wrote an assessment of my mental status, my memory, my ability to understand financial matters. It's dated March 18th. Silly. The petition was filed on March 23rd. The assessment came 5 days before. Diana filed it with the court the same day the petition arrived. Celie understood what that meant. It meant I hadn't been reactive. It meant I hadn't panicked. It meant I had anticipated exactly what my children were going to do, and I had built the defense before they built the offense.
"Oh, who's the doctor?"
Celie asked. Patricia Thornton. She was at our house for Sunday dinners when the children were young. They called her Auntie Pat. Celie's expression shifted. She understood the weight of that. It wasn't just that I had a neurologist's assessment. It was that the neurologist was someone my children had known, someone they had trusted, someone who could stand in a courtroom and say that she had known me for decades and that I was not incapacitated. I was not confused. I was not vulnerable. I was exactly who I'd always been. I showed Celie the petition again, and I read the language out loud, slowly, letting her hear the claims. The phrase about complex financial transactions, the phrase about undue influence, the request for the guardianship, the request to block the sale. The language was designed to sound like protection, like a child worried about their aging mother, like care, like love. But the effect was clear. If the petition was granted, I would no longer own my own property. I would no longer have the right to make financial decisions. My children would have legal control over me, and my house would stay in their hands because the sale would be blocked. What happens next? Celie asked. The hearing is set for Tuesday, April 8th at 9 a.m. before Judge Thomas Harwell. Diana will be there. Dr. Thornton will be there. My documents will be there. And the appraisal, the mortgage statements, the repair receipts, everything that proves I've been managing a $387,000 asset alone for 12 years. And my children will be there with a petition that claims I can't understand financial transactions. And then the judge reads the evidence. And the judge asks questions. And the petition falls apart. I set the petition aside on the counter. I didn't look at it again. I didn't need to. I'd already read every word. I'd already understood every claim. I'd already seen the moment where it was going to fail. Celie and I sat at the kitchen table and drank our coffee. The afternoon light moved across the surface. Outside, the world continued exactly as it had that morning. People went to work. Children came home from school. Life moved forward. But in my kitchen, in the space between two women, something had shifted. The petition had arrived, and with it, the confirmation of everything I'd expected. My children had done exactly what I'd predicted. They had filed exactly what I'd prepared for. They had walked straight into the trap without knowing it was there.
"They picked the wrong woman,"
Celie said finally. They did, I agreed. They really did. I looked at the petition sitting on the counter. 5 pages of lies. 5 pages of clinical language designed to make theft sound like protection. 5 pages that were going to fall apart the moment Diana Castillo stood up in front of Judge Thomas Harwell and submitted her exhibits. The text message from Devon, the neurologist's assessment, the 12 years of mortgage statements, the appraisal, the repair receipts, the proof that a woman who had managed a $387,000 property alone for 12 years understood exactly what complex financial transactions meant. The petition didn't frighten me. What it did was confirm that I had been right to prepare. It confirmed that my children were exactly as predictable as I'd thought they were. It confirmed that they had no idea who they were dealing with. And it confirmed that when they walked into that courtroom on Tuesday, April 8th, they were going to discover, in about 8 minutes, that they had made a catastrophic mistake. Celie texted me at 9:23 p.m. on a Thursday in early February. It was a church function, one of those events where people stand around in the fellowship hall, eating finger food and updating each other on their lives. I wasn't there that night. I was home. But Celie was, and she'd overheard something that made her leave early and drive straight home and send me a text in all caps. Call me. I called her at 9:31 p.m. I just heard Marcus asking another lawyer, someone from the church, about Tennessee guardianship law. Celie said, no preamble, no build-up, just the thing. He was asking whether it could be used to pause a real estate transaction if a parent was selling something without family approval. He used the word incapacity. He wanted to know if you could petition the court to put a hold on a sale pending a guardianship hearing. I sat down at my kitchen table. The house was quiet around me. Did he see you? I asked. No, he was in the hallway. He had no idea I was there. But Vivienne, he was specific. He knew what he was asking. I understood what that meant. Marcus hadn't stumbled into a vague question about family dynamics. He had researched guardianship law. He had thought about how it could apply to my situation. He had decided that a legal petition was a viable strategy for stopping my sale. He had already moved past conversation and anger into planning. Thank you, I said. Thank you for telling me. I hung up and sat in the quiet kitchen and understood that I was not going to leave Memphis without a fight. I was not going to sell the house peacefully. My children were going to try to take control of my finances, and they were going to believe they had the legal right to do it. They were going to believe they were protecting me. They were going to believe they were reasonable, and they were going to be entirely wrong. I had two options. I could ignore the warning and hope nothing happened, or I could get ahead of it. By the next morning, I had called Diana Castillo's law office and asked for an appointment to discuss elder law and asset protection. The woman on the phone told me that Diana had an opening on Friday at 2 p.m. I took it. Diana Castillo's office was in a building on Madison Avenue, 3 blocks from my house. The office was quiet, professional, lined with books about family law and estate planning and the legal landscape of aging in America. Diana herself was a woman in her late 40s with grey in her hair pulled back in a neat knot, and the kind of direct gaze that made you feel like she'd already read your case file before you walked in the door. She'd been practicing elder law for 23 years. She specialized in guardianship disputes. She knew what predatory families looked like. She knew what protective families looked like, and she could tell the difference in about 60 seconds. I sat across from her and explained the situation. I was 61. I was retiring in December. I owned a house that was paid off, purchased in 1991 for $94,000. I wanted to sell it and move to Savannah. My adult children had not been consulted about this decision, and I had reason to believe they would object. I had heard through a reliable source that one of them was researching guardianship law. I wanted to know what protections I had. Diana listened without writing anything down. She sat back in her chair and looked at me the way a woman looks at another woman when she's sizing up whether you're the kind of person who tells the truth. When I finished, she set down her pen and leaned forward slightly. They would need to prove incapacity, she said. Not disagreement, not concern, not a family vote or a moral objection. The standard in Tennessee is clear and convincing evidence of incapacity. That's a high bar. It's not just difficult, it's extremely difficult. A judge would need to see objective evidence that you cannot understand the nature and consequences of your decisions, that you cannot manage your financial affairs, that you require a guardian to make decisions for you because you are incapable of making them yourself. Disagreeing with a financial decision you're making, even strongly, doesn't meet that standard. No matter how much your children believe they're right, no matter how much they believe they're protecting you. What kind of evidence would meet that standard? I asked. Medical evidence. A neurological assessment from a qualified neurologist. A psychological evaluation from a licensed psychologist. Testimony from healthcare providers who have observed cognitive decline. Concrete examples of poor judgment in other areas of life. Not just this one decision, but a pattern of inability to manage finances or understand reality. Documented instances of confusion, memory loss, inability to follow complex information. And even then, a good judge will look at what you've actually done. Your history, your competence, your record of managing complex decisions. A woman who has paid off a mortgage alone for 12 years and managed a property responsibly, that's going to weigh very heavily against a petition that claims she can't understand financial transactions. I understood what she was telling me. If my children filed a guardianship petition without medical evidence, without a pattern of documented incapacity, based only on the fact that I was selling my house against their wishes, the petition would fail. The law would protect me. The standard was high enough that my own competence would be shield enough. But I also understood the unspoken second part of what she was saying. If they were smart, if they anticipated my defenses, they would get a doctor to evaluate me. They would create the appearance of medical concern. They would make the petition look legitimate. They would find a physician willing to testify that I showed signs of incapacity. And then the case would be much harder to win. I want to get ahead of this, I said. I want a neurological assessment from a qualified doctor, dated before they file, that establishes my cognitive capacity. I want documentation of my financial competence. I want evidence that I understand exactly what I'm doing. Diana nodded slowly. That's smart. That's exactly what I would recommend. We can have you evaluated by a neurologist. Get that assessment in writing, signed and dated. We'll keep it in my files. And if they file a petition, we'll submit it with the courts. Evidence that contradicts their claims before they even get to present them. The assessment will be dated before the petition. It will show that a medical professional found you to be fully competent. And in the meantime, we document everything you do. The appraisal, the real estate listing, the buyer negotiations, everything that proves you understand your own financial affairs and are making a deliberate, rational choice. How much? I asked. My retainer is $3,500. That covers the negotiations, Everything that proves you understand your own financial affairs and are making a deliberate, rational choice. How much? I asked. My retainer is $3,500. That covers the initial consultation, advice on strategy, and preparation for any legal filings that come. If we end up in court, we'll discuss additional fees at that time. I wrote her a check for $3,500 right there in her office. The date was March 9th, 2026. I signed my name and the amount and the date, and I handed it to her. She looked at the check and set it down on her desk without commenting. She didn't say, "Good choice," or "You're going to need this," or any of the things that acknowledge the weight of what's being decided. She just accepted it. Diana referred me to Dr. Patricia Thornton, a neurologist at Mercy General Hospital who specialized in cognitive assessment for older adults. Dr. Thornton had been at my house for Sunday dinners when the children were young. She'd held Renata when she was a baby, back when Renata was 3 months old, and still waking up at 3 thumbs. And the house was full of that particular exhaustion of new parenthood. She'd listened to Marcus talk about his first job at Mid-South Finance. She'd sat at my kitchen table and drunk my coffee and laughed at Raymond's jokes. She'd been there the day Raymond died, in February 2014. She'd signed his death certificate. Now she was going to evaluate whether my children had the legal right to steal my house by claiming I'd lost my mind. I called her office and made an appointment for the following Friday, March 18th. When I walked into her examination room, she stood up and hugged me. The hug was careful, professional, but it was still a hug. It was the hug of a woman who remembered me from before any of this, who knew exactly what was happening and what she was about to do. "Diana called me," Dr. Thornton said. She gestured for me to sit in the examination chair. She explained the situation. "I'm going to do a complete neurological assessment. It's thorough, and it takes time, but it's going to be ironclad. I'll test your memory, short-term and long-term. I'll assess your cognition. I'll ask you about complex concepts and how you process information. I'll ask you in detail about your financial decisions. I'll ask you about your reasoning and your understanding of the consequences of those decisions. And then I'm going to write a report that documents exactly what I find." The assessment took 2 hours. I answered questions about recent events, what I'd had for breakfast that morning, what day it was, what season, questions about historical facts, when I was born, when I got married, when I retired, questions about mathematical concepts and abstract reasoning. She asked me to draw a clock and set the hands to 11:10. She asked me to remember 3 words and repeat them back to her after 5 minutes. She gave me a list of numbers and asked me to repeat them in reverse order. Then we moved into the specifics. She asked me to walk her through the decision to sell the house. She asked me why I'd decided to sell. She asked me about the timeline. When I'd decided, when I'd called a real estate agent, when I'd gotten the appraisal. She asked me about the offer from the Buckhead buyers, the price, the terms, the timeline for closing. She asked me to explain my understanding of the mortgage, the taxes, the insurance, the maintenance costs. She asked me to describe the house, how many bedrooms, how many bathrooms when it was built, what repairs it had needed. She asked me why I wanted to move to Savannah. She asked me about my financial situation, my retirement income, my assets, my plans for the proceeds from the sale. By the end, Dr. Thornton had documented, in clinical language and with objective test results, that I was cognitively sound, that I understood complex financial concepts, that I was capable of making informed decisions about my assets. She had documented that my memory was intact, that my reasoning was clear, that I could articulate my rationale for my decisions, that I understood the nature and consequences of what I was doing. She dated the report March 18th, 2026. She signed her name and her medical credentials. She made a statement. The patient presents with no evidence of cognitive impairment, memory loss, diminished mental acuity, or reduced capacity. Her understanding of complex financial transactions is entirely appropriate for her age and education level. She demonstrates clear reasoning about her financial decisions and the ability to articulate her rationale for those decisions in detail. She understands the nature and consequences of her planned real estate transaction. In my professional opinion, the patient is fully capable of managing her own financial affairs without the need for a guardian or other protective intervention. That report was 14 pages. It included test results and clinical observations and Dr. Thornton's professional assessment. That report was going to become Exhibit B in a courtroom. That report was going to sit on a judge's desk and destroy every claim my children made about my mental state. When I brought the report to Diana's office the following Monday, March 24th, the day after the petition was served, she read it slowly, page by page, and when she set it down, she smiled at me in a way that suggested she had been waiting for exactly this. "They filed," she said. "Yesterday morning, a process server came to my door. And you didn't warn them!" "No. And you're not going to—" "No." Diana looked at the report again. "This is going to destroy them," she said. It wasn't cruel when she said it. It was just factual. It was just the truth. The petition claims you can't understand financial decisions. This report says you understand them perfectly. The petition was filed 2 days after this assessment. The timing is going to raise the question of whether they knew you'd been evaluated and filed anyway. The specificity of the report is going to make their claims look like fiction. "What happens next?" I asked. "We file the report with the court. We file a motion to dismiss based on lack of evidence. We prepare for a hearing, and we wait to see if they want to proceed or if they back down when they realize what they're walking into." "They won't back down," I said. Diana looked at me. "How do you know?" "Because Marcus is in debt. Because Devon borrowed money from me and never repaid it. Because they see this house as something they're entitled to. They won't back down. They'll come. They'll just lose." "Are you prepared for that?" Diana asked. "For your children to petition the court claiming you're incapacitated. For the public record to include their allegations. For the world to know that your own children believe you've lost your mind. It's not going to be pleasant. It's not going to be clean." I thought about that. I thought about my children's names on legal documents. I thought about their claims about my mental state sitting in a courthouse file. I thought about what it would feel like to have those words written down, filed with the court, entered into a record that would exist forever. Then I thought about the alternative. I thought about walking into a courtroom unprepared while my children presented a petition claiming I was incapacitated. I thought about the possibility that a judge, seeing an unrepresented elderly woman facing a petition from 3 adult children, might grant temporary guardianship while the case was pending. I thought about losing control of my own house, my own money, my own decisions, while this played out in court. I thought about what it would feel like to have my children make those decisions for me. To have them divide the house 3 ways. To have them decide how I spent my retirement. I want them to come, I said. I want them to file. I want this to be over. Diana set down her pen and looked at me for a long moment. She was gauging something. She was looking at whether I had the spine for what was about to happen. She was looking at whether I could hold my nerve while my children betrayed me. Whether I could stay silent and let them walk into a courtroom believing they had the advantage. Whether I could trust the law and the evidence and my own competence. Then here's what we're going to do, she said. We're not going to tell your children that you have counsel. We're not going to tell them that you have a neurological assessment. We're not going to tell them anything. You're going to act like you don't know they're planning this. You're going to let them believe they caught you unprepared. You're going to sit across from them in a courtroom. And you're going to look vulnerable. And when they think they have you, when they think they've won, we're going to submit these exhibits. And we're going to show them exactly how wrong they are. I understood what she was asking. She was asking me to let my children betray me without warning them. She was asking me to know they were coming and stand there anyway. She was asking me to trust that the law would protect me and that the evidence would speak for itself. She was asking me to take a risk that most people can't take because most people have to warn their children. Most people have to give them a chance to back down. Most people have to preserve the relationship. Yes, I said. You're absolutely sure. And I'm sure. Diana leaned back in her chair. Most people can't do this. Most people are too kind. But your children aren't most children. And you're not most people. They're going to come for your house. And you're going to let them walk into a courtroom they think is empty. And they're going to discover that it's anything but. Over the next 2 weeks, I went about my life exactly as though nothing was happening. I went to church. I had lunch with Celie. I called the real estate agent and got the house appraised. I showed the house to interested buyers. I fielded a serious offer from people from Buckhead, a neighborhood in Atlanta. I accepted the offer contingent on final inspections. Everything public, everything documented, everything designed to look like the actions of a woman who understood exactly what she was doing. And every night, I sat at my kitchen table and looked at the documents Diana had given me. The retainer agreement, signed and dated. The neurological assessment, dated March 18th, 5 days before the petition was filed. The strategy, written out in Diana's careful handwriting. Oh, let them file. Let them believe I was unprepared. Let them walk into a courtroom where every advantage they thought they had would dissolve before the judge even finished reading the exhibits. I had done something that most people can't do. I had looked at people I loved and understood that they were capable of betrayal. I had prepared for that betrayal without warning them away from it. I had built a trap and baited it with my own apparent vulnerability. I had documented my own competence in clinical language so that when they tried to claim I'd lost my mind, the evidence would prove they were lying. Celie was the only one who knew. We didn't talk about it explicitly. She knew what I was doing. She knew I was waiting. one Sunday after church. She walked past me and squeezed my shoulder and whispered, "You've got this." That was all. That was enough. By late March, I was ready. The house was on the market. The offer from Buckhead was pending inspection. Diana's retainer was paid. Dr. Thornton's assessment was in Diana's files. The documents that proved I understood financial decisions were organised in a manila envelope labelled House. Everything that my children needed to believe was true. That I was unprepared, that I was vulnerable, that I was alone, was exactly what I wanted them to believe. They had no idea that a woman sitting in a kitchen in Memphis had already won the war before they'd even filed the first document. They had no idea that when Marcus asked that lawyer at church about guardianship law, he was walking into a carefully prepared legal landscape where every single one of their claims was going to fail. They had no idea that the woman they were preparing to petition the court against was already 3 steps ahead, already prepared, already waiting. I was ready for them. I was ready for the petition. I was ready for the courtroom. I was ready for the moment when Diana stood up and submitted her exhibits, and a judge read the evidence of a woman's competence and dismissed their petition before either of my children finished saying their first word. But first, I had to wait. First, I had to let them come. First, I had to stand there, knowing what was coming, and let them walk into the trap they had built for me. I could do that. I had been doing that my whole life, standing still while other people moved. It was time to stand still for a different reason. It was time to stand still and let them come. The call came at 8:11 on Tuesday, April 8th, 2026. I was in the blue bathroom upstairs, finishing my makeup, when my phone rang. I knew it was one of the children without looking. There was a particular urgency in the way it was ringing. The kind of urgency that comes from a decision someone is regretting in real time. It was Devon. His voice was different from how I'd heard it in weeks. Strained, like he'd been awake for hours and was running on fumes. "Mama, I need to talk to you about something," he said. I set down my eyeliner and waited. I didn't say anything. I let him fill the silence because people who are uncertain always fill silences with the truth. Renata was up all night. She's been crying since about 3 a.m. She called me at 2, asking me questions about the petition, and I realized, Mama, I don't think Marcus told her what the petition actually says. She thinks we filed it to protect you. She thinks we filed it because we're worried about the sale happening too fast. She thinks we're trying to make sure you've considered all your options. She doesn't understand that it's about blocking you from making your own decisions. She doesn't understand that we're claiming you're incapacitated. I set the eyeliner down carefully on the counter. I didn't interrupt him. I didn't correct him. I let him say what he needed to say because he was finally, for the first time in this entire thing, being honest about what we were actually doing. I don't think she would have signed it if she'd understood what it was actually claiming. He continued, "When I read the language back to her, the part about you being no longer capable of understanding complex financial transactions, she started crying harder. She said that's not what she signed. She said she signed something about protecting the house, not about proving you're mentally incapable. And now we're about to walk into a courtroom in less than an hour, and she's going to hear the judge read that language, And she's going to realize what we're actually doing. And Mama, I don't know if we should do this. I don't know if we should proceed. Maybe we should call it off before this goes any further. Maybe we should withdraw the petition before the judge sees it, before it gets worse. His voice was breaking now. This was Devon at his most human, uncertain, afraid, realizing too late what he'd agreed to. This was the version of my son who still had a conscience. I held the phone and I considered it. For 60 seconds, I actually considered it. I considered calling Diana and telling her to request a continuance. I considered stepping into that courtroom and asking to speak to the judge privately and requesting to withdraw the petition. I considered the possibility that if I did that, if I backed down, if I gave my children a way to undo this without humiliation, that they might learn something, that Devon might understand what he was about to do and find the courage not to do it, that Renata might grieve the loss of her father without displacing that grief onto a house and onto the woman who had raised her, that maybe this could end in a way that didn't require me to destroy them. 60 seconds. That was the entire window. That was all the time I allowed myself to think about Mercy. Then I heard a shift on the line. A hand covering the phone. Devon's voice. Distant. "Marcus! I'm just calling her to see." Then Marcus was there. "You've already lost, and you don't know it yet." "Mama," he said. His voice was flat, unhurried, certain. He was telling me that he understood what was about to happen. He was telling me that he believed he was going to win. He was telling me that he believed I was alone, unprepared, that I didn't have an attorney waiting, that I didn't have a neurologist assessment ready to submit, that I was going to walk into that courtroom confused and frightened, and that he was going to be the one who saved me from myself. I heard everything he wasn't saying in that sentence. I heard the arrogance. I heard the certainty. I heard the belief that a woman who had paid off a house alone for 12 years, who had managed a property worth $387,000, who had kept every receipt and every mortgage statement and every appraisal, that she was incapable of understanding financial decisions. I heard the belief that he had the right to take that away from her. I heard the belief that he was going to win. That was when the door closed. That was when every window shut. That was when I understood that there was no going back, no turning away, no possibility of backing down and letting my children save face. "I'll see you in court, Marcus," I said, and I hung up the phone. I set it down on the bathroom counter next to my eyeliner. I looked at myself in the mirror. My face was calm. My hands were steady. I finished my makeup with the same careful precision I always used. I applied my lipstick. I checked my hair. I made sure everything was exactly as it should be. Then I went to the bedroom and I took Raymond's lapel watch from where it was sitting on the dresser. The watch he wore on his military uniform. The watch that kept perfect time. And I pinned it to my jacket. I looked at the pin. I looked at the watch. I looked at myself in the mirror one more time. I picked up the manila envelope. The envelope that held 12 years of mortgage statements. The envelope that held the deed from 1991 and Raymond's handwriting on the inspection notes. The envelope that held the appraisal from March 6th, dated before the petition was filed, showing $387,000. The envelope that held the proof of what I had built, what I had maintained, what I understood.
I went downstairs.
Silly was waiting in the driveway in her blue Buick. The morning was clear. The sky was that bright blue that comes in early April in Memphis. The kind of blue that makes you want to live forever. The air was cool. I could hear birds somewhere in the neighborhood. Everything looked exactly the same as it always did. The street was the same. The sidewalk was the same. The world hadn't shifted, but everything was about to change. I got in the passenger seat and set the envelope on my lap. Silly was wearing her church clothes, a dark dress, gold earrings, her hair pinned back. She looked at me and didn't ask any questions. She didn't ask what happened. She didn't ask if I was all right. She didn't ask if I wanted to talk about Devon's call or Marcus's threat or the way my son had told me I'd already lost. She just started the car and pulled out of the driveway, heading toward downtown, heading toward the courthouse, heading toward the moment that would determine whether I would ever own my own choices again. We drove in silence for most of the trip. The city moved past us. The streets I'd lived on for 35 years. The neighborhoods where I'd taught 3rd grade and then been promoted to vice principal. The corners where I'd bought groceries. The church where I'd spent 3 decades of Sundays. Everything was about to be different. In about 45 minutes, I was going to walk into a courtroom and either defend my right to my own life or lose it. There were no other options. There was no middle ground. As we pulled into the courthouse parking lot at 8:54, Silly cut the engine. We sat there for a moment in the quiet. The building rose up in front of us, a concrete structure, official and imposing and designed to make you feel small. Inside that building, the machinery of justice was already in motion. Inside that building, my 3 children were waiting. They didn't know what I knew. They didn't understand what was about to happen. Silly turned to me and reached across the console and took my hand. Her grip was warm and steady. I could feel the truth of her in that grip. I could feel all the years we'd known each other. All the time she'd stood with me. All the time she'd been there. "Lord," she said, and her voice was even and clear and steady. "Let her walk straight in." 6 words. That was all the prayer she gave me. Not a prayer for victory, not a prayer for justice, just a prayer for straight passage, just a prayer that I would walk into that courtroom the way I needed to walk into it, without hesitation, without looking back, without doubt. I picked up the envelope. I held it against my body. I got out of the car and I stood for a moment in the parking lot, feeling the weight of it, feeling the reality of it, feeling the moment that was about to arrive. The courthouse steps stretched ahead of me. The doors were glass. Inside, I could see people moving. Lawyers in suits, clerks, families, the machinery of justice turning. Inside those doors, in the hallway, my 3 children were standing. I could see them without looking directly at them. I could feel them the way you feel someone watching you. I didn't hesitate. I didn't look around. I walked up the steps toward the glass doors. I didn't hurry. I didn't rush. I walked the way a woman walks, who has made a decision and intends to see it through. The doors opened in front of me. The air inside was cool and recycled. The hallway smelled like the inside of a courthouse, like old wood and paper, and the weight of decisions that would not be unmade. I could see them now. Marcus in a dark suit, standing with his attorney, looking confident. Devon standing apart, looking like he hadn't slept, looking smaller than I remembered him being. Renata with her arms crossed, her face blotchy and raw from crying. They were all looking at me, and I was walking toward them. And I didn't stop. I didn't acknowledge them. I didn't let my eyes land on any of their faces. I walked straight past them toward the courtroom doors. The courtroom doors were ahead. Everything slowed down. Every step felt deliberate. Every breath felt counted. I could hear the sound of my own footsteps on the tile floor. I could hear the courtroom doors creaking as someone moved inside. I could hear the judge's clerk arranging papers. And then, I was there. I was pushing open the courtroom doors. The judge hadn't entered yet. The courtroom was mostly empty. A few clerks. The court reporter, the bailiff, and Diana Castillo, sitting at the respondent's table, looking up when I came in. Her expression didn't change, but something in her eyes shifted. Recognition. Confirmation. She was ready. She had been ready for weeks. And now it was here. I walked to the respondent's table and I set the manila envelope down in front of her. Not gently, deliberately. The envelope with 12 years of proof. The envelope with the evidence of who I was and what I understood. I sat down next to Diana without looking back at the courtroom entrance. I didn't turn around. I didn't watch my children come in. I didn't watch the moment when they understood that I was represented, that I was prepared, that they had walked into a courtroom they believed was empty and discovered that it was anything but. Diana leaned toward me and whispered, "Are you ready?" "Yes," I said. "And I meant it. I was ready. I had been ready since March 9th. I had been ready since I paid Deanna's retainer. I had been ready since Dr. Thornton wrote her assessment. I had been ready since I decided not to warn my children. I had been ready since the moment I understood that they were going to try to take my house and my choices and my life, and that I was going to make them regret the decision." The judge entered through a side door at 9:02 a.m. He was a man in his late 50s, with grey in his hair and the kind of face that had seen 1,000 family disputes and had developed the ability to read people in about 30 seconds. His name was Judge Thomas Harwell. He sat down at the bench and looked at the courtroom. His gaze moved from the petitioner's table to my table, and I saw the moment when he understood that there was legal representation on both sides. I saw the moment when he understood this wasn't going to be an easy petition to grant. He looked at his docket. He looked at the petition in front of him. He adjusted his glasses. He took a breath. "This is the matter of Hargrove versus Hargrove, a petition for limited guardianship," he said. "Let's begin." And the 8 minutes that would change everything started counting down. Marcus's attorney stood up when the judge entered. He was a man in his early 50s, with the kind of confidence that comes from winning cases for people with money. He launched into his opening statement before the judge had even fully settled in the chair. "Your Honor," he said, "the respondent appears before this court without legal representation. We have 3 concerned adult children who have filed a petition based on legitimate medical concerns about their mother's capacity to manage complex financial decisions. This is a straightforward matter. The respondent has recently made the decision to sell a significant property and relocate without consulting her family. We believe she is vulnerable to undue influence and lacks the capacity to understand the nature and consequences of this transaction.
He sat down. He looked confident. He looked like a man who believed he was about to win.
That was when Diana stood up. "Your Honor, I would like to introduce myself for the record. My name is Diana Castillo, and I am a licensed elder law attorney with the state of Tennessee. Bar number 428716. I represent the respondent, Vivienne Dolores Hargrove. Before counsel continues, I would like to request 5 minutes to submit 4 exhibits that I believe are material to this case. I would appreciate the opportunity to enter these into evidence before we proceed with testimony."
The judge looked at Diana. He looked at Marcus's attorney. He nodded. "Proceed," Judge Harwell said.
Diana stood and walked to the judge's bench, holding 4 documents. She moved with the kind of deliberation that made every step matter. She was a woman who understood that this moment was about evidence, not emotion. She was a woman who understood that the judge needed to see what we had brought into this courtroom.
"Exhibit A,"
Diana said, and she handed the first document to the judge. It was the text message. Devon's text. November 21st. No, March 21st, at 11:02 p.m. The message where he asked about the equity split. The message where he revealed his financial motive. The message that was dated 2 days before the petition was filed. Judge Harwell took the document and read it. His expression didn't change, but his eyes moved carefully over the words. Then he read it aloud. "Mama, I just need to know what happens to the equity split. Marcus says we're all entitled to weigh in before you sign anything with those buckhead buyers," he said. He set the document down. He looked at Marcus's attorney. "Counsel, can you explain what this communication means in the context of a petition claiming the respondent lacks the capacity to understand financial decisions?" Marcus's attorney opened his mouth. He closed it. He opened it again. "Your Honor, that text is just one of the children expressing concern about the transaction."
"The text references an equity split,"
the judge said. "That suggests financial interest, does it not?" "Well, yes, but..." Diana handed the second document to the judge. "Exhibit B, Your Honor, a neurological assessment dated March 18th, 2026, conducted by Dr. Patricia Thornton, a neurologist at Mercy General Hospital." The judge took the assessment. It was 14 pages. It included test results and clinical observations and Dr. Thornton's professional findings. The judge began reading. He didn't skim. He read carefully, page by page. In 90 seconds passed. Then 95. The courtroom was silent. No one moved. Everyone was waiting. After 90 seconds, the judge looked up. He set the assessment down on the bench. He looked at Marcus's attorney. "This assessment was dated March 18th?" he asked.
"Your Honor, we weren't aware,"
Marcus's attorney began. "March 18th, the judge repeated. The petition was filed March 23rd, 6 days later. A neurologist had already evaluated the respondent and found no evidence of cognitive impairment." Diana handed him the third document. "Exhibit C, Your Honour, the respondent's property management file. This contains the original deed from September 1991, inspection reports, 34 years of mortgage statements, and documentation of every repair and maintenance decision made on the property since purchase. The judge took the file. It was thick. A physical representation of 34 years of competence. He paged through it. He saw the original deed. He saw Raymond's handwriting on the inspection notes from 1991. He saw the mortgage statements. Every one of them in Vivienne's name. Every one of them marked paid in full. He saw the repair receipts, organized by year. He saw the evidence of a woman who understood what she owned and managed it alone for 12 years after her husband died. This respondent purchased this property in 1991 for $94,000, the judge said. He was reading aloud now, talking through what he was seeing. And she has maintained comprehensive documentation of every financial decision related to that property for 34 years. Is that correct, counsel?
Your Honour, yes, but...
Diana handed him the fourth document. Exhibit, Your Honour. An appraisal dated March 6th, 2026, conducted by Marco Reyes, a licensed real estate appraiser. The current appraised value of the property is $387,000. The judge looked at the appraisal. He set it down on the bench next to the other exhibits. He looked at the documents in front of him. He looked at Marcus's attorney.
Let me ask you a question,
Judge Harwell said. His voice was very quiet.
What is the legal standard for guardianship in the state of Tennessee? Your Honour, the petitioner must show clear and convincing evidence of incapacity.
Some clear and convincing evidence, the judge repeated. Not disagreement, not concern, not a family vote. Clear and convincing evidence. And does any document your clients have submitted, the petition itself, any testimony, any evidence, does any of it meet that standard? The courtroom was silent. Marcus's attorney looked at the documents in front of the judge. He looked at the petition he had drafted. He understood what had just happened. He understood that his clients had walked into a courtroom believing they had an advantage. And in 8 minutes, that advantage had been dismantled by evidence they didn't even know existed.
Your Honour,
Does it meet the standard? The judge asked again. 6 seconds of silence. 6 seconds where no one spoke. 6 seconds where everyone understood that the petition was over. Your Honour, it does not, Marcus's attorney said finally. Judge Harwell set down his pen. He looked at the courtroom. He looked at Diana. He looked at me. The petition for limited guardianship is dismissed, he said. Dismissed with prejudice, and the respondent retains full legal capacity and full authority over her financial decisions. I see no evidence of incapacity. I see, in fact, evidence of a woman who has managed a significant financial asset alone for 12 years and understands complex financial transactions better than most people I encounter in this courtroom. This case is closed. He brought his gavel down. 1 strike. The sound echoed in the courtroom. 8 minutes. That was all it took. 8 minutes from the moment Diana stood up to the moment the judge dismissed the petition. I sat there in the silence that followed. I didn't move. I didn't cry. I didn't smile. I just sat very still and felt the weight of what had just happened. My children had come to take my house, and they had failed. They had come to prove I was incapacitated. And instead, they had proven that they were willing to lie about their own mother in a courtroom. They had come believing they had the advantage, and they had discovered that they were walking into a trap. Then Marcus turned in his chair. He turned slowly, deliberately, and he looked at me for the first time since we'd walked into the courtroom that morning. His face was white. His jaw was clenched. Gahari, he was looking at me with the expression of a man who had just realized he had lost everything. I looked back at him. I looked at him with the expression I had been saving since Monday night when he had told me, "You've already lost, and you don't know it yet. Mama." I looked at him with the expression of a woman who had known exactly what was coming, who had prepared for it, who had walked into that courtroom knowing that in 8 minutes, the truth was going to be laid out in front of a judge, and there was nothing he could do to stop it. In my expression, he understood. He understood that I had known. He understood that I had been prepared. He understood that I had let him file the petition knowing exactly what would happen when he did. He understood that every advantage he thought he had was something I had already counted and neutralized. His face changed. The confidence drained out of it. The certainty disappeared. What was left was just a man who understood, finally, that he had underestimated the woman he was trying to destroy. I didn't say anything. I just looked at him. I held that look. I let him feel the weight of it. I let him understand that this was what it meant to pick the wrong woman to betray. Then I turned away. I gathered my documents from the table. I stood up and I walked toward the courtroom doors without looking back. Diana gathered her files and followed me. When I reached the doors, I pushed through them into the hallway. Silai was standing there. She was waiting in the hallway outside the courtroom, and when she saw my face, she already knew. She didn't need the words. She just pulled me into a hug and held me there for a moment while everything I'd been holding steady finally came to rest. "It's over," I said. "It's over," Celie confirmed. And it was. The petition was dismissed. My children had lost. I had won. The house was mine, and the sale was going to proceed, and I was going to move to Savannah, and there was nothing my children could do to stop me. The house on Magnolia Drive sold on April 18th, 2026, 10 days after the hearing. The Buckhead buyers had been waiting. The inspections had passed. The appraisal held. All the pieces fell into place exactly as they were supposed to. I closed on the sale and I received a check for $387,000. That was the number. That was what my house was worth after 34 years of my stewardship. After 12 years of managing it alone. After keeping every receipt and every mortgage statement and every repair invoice. After understanding exactly what I owned, I deposited that check into my account. I called a moving company. I packed the house that had been my home for 35 years. I said goodbye to Celie. I said goodbye to the church. I said goodbye to Memphis. And I drove to Savannah in my car with the windows down, listening to music I hadn't heard in years, feeling the weight lift off my shoulders like a physical thing leaving my body. I was 61 years old. I had spent my adult life building a life for other people. For Raymond. For my children. For the students I'd taught. for the community I'd served. Now I was going to build a life for myself. I was going to buy a house outright with cash. I was going to have a porch and a garden. I was going to have a door that was mine and only mine. I had earned that. I had earned it through 34 years of hard work. I had earned it by understanding what I owned. I had earned it by refusing to let my children take it from me. I had earned it by walking into a courtroom knowing exactly what was coming and letting them learn the hard way that they had picked the wrong woman to underestimate. The petition was dismissed with prejudice. That meant Marcus, Devon, and Renata could never file it again. They could never come back to court and try the same thing twice. The dismissal was permanent. The record would show that they had lost, and that loss was final. Diana came to see me the day after the hearing. We sat at my kitchen table with coffee and papers spread out between us. She was explaining my options regarding sanctions. Whether I wanted to pursue a claim against petitioner's counsel for filing a frivolous petition. The attorney fees could be substantial. The humiliation to Marcus's attorney could be significant. I listened to her explain the legal framework. I understood the options. And then I told her pooh. Why not? Diana asked. Because I've already won. I said, my children lost. They know they lost. They know that they walked into a courtroom and were destroyed by their own mother's competence. If I go after the attorney too, it becomes about me being vindictive. It becomes about punishment. I don't need punishment. I need closure. Diana nodded. She understood. She closed her folder and we didn't talk about sanctions again. The house closed on April 18th, 2026, 10 days after the hearing. The Buckhead buyers had been waiting. The inspections had cleared. The appraisal held. I received a wire transfer of $387,000 into my account. That was the number. That was what my house was worth. That was what my 34 years of stewardship had created. I deposited the check. I started packing. On April 11th, before the closing, Renata called me. She called alone. No Marcus, no Devon, just her voice on the phone. Small and uncertain. Mama, I need to talk to you about something, she said. Okay, I said. I didn't understand what the petition said. I read it after we filed it, and I realized that we were claiming you were incapacitated. We were claiming you couldn't understand financial decisions. And Mama, I didn't think that's what we were signing. Marcus told me we were filing to protect the house, to make sure you'd considered all your options. He told me we just wanted a say in what happened. He didn't tell me we were claiming you were mentally incapable. I let her say what she needed to say. And I've been thinking about Daddy, she continued. Her voice was breaking now. I've been thinking about how much he loved that house. And I know I said the house was about him, that we needed to keep it for him. But the truth is, I didn't know how to let him go. I didn't know how to accept that you were leaving Memphis. I didn't know how to accept that his house was going to belong to someone else. And I took that and I made it about protecting you, when really I was protecting myself. Renata, I said. And then you came to court and you had a lawyer and you had a doctor saying you were fine. And you had all these documents showing you understood everything perfectly. And I realized that you didn't need protecting. You never needed protecting. Marcus made me think you did. But you didn't. I sat with that for a moment. I sat with the fact that my youngest child had finally understood what she'd done. "Where do we go from here?" I asked her. "I don't know," she said. "I don't know if you can forgive me." "It's not about forgiveness," I said. "It's about whether you understand what you did and whether you're willing to do the work to rebuild what you broke." "I understand," she said, "and I want to try." We didn't resolve everything in that phone call. We didn't erase what had happened, but we opened a door that had been closed. We started a conversation that had been interrupted, and that was enough. That was all I needed. Devon called a week later. He didn't call to apologize. He called because Diana had sent him a letter about the loan he'd borrowed from me in 2021. $23,000. Never repaid. Now documented in the court record. She was asking when he planned to repay it. He called me directly instead of going through Diana. "Mama, I'm going to pay you back," he said. "The money I borrowed. I know I said I would pay it back in 2 years, and it's been more than that, and I've been avoiding it. I was afraid to talk to you about it because I knew I'd broken my word, but I can't avoid it anymore. I'm going to set up a payment plan, and I'm going to pay you back every cent." "Okay," I said. "I should have done this years ago," he said. "Yes," I said. "You should have." We didn't say much more than that. But he knew what he had done. He knew that his silence had been complicit. He knew that by signing the petition without reading it carefully, by letting Marcus drive the decision, he had betrayed me. And now he was at least acknowledging it. It wasn't redemption, but it was a start. I packed the house room by room. I sold furniture I didn't need. I donated clothes that didn't fit anymore. I kept the things that mattered. Photographs. Raymond's watch. The Bible my grandmother gave me. The recipes written in my mother's handwriting. The blue mug from Raymond's army battalion. I kept the things that reminded me of who I'd been and what I'd survived. On May 2nd, 2026, I locked the door of 1404 Magnolia Drive for the last time. I stood on the porch for a moment and I looked at the house. It was a beautiful house. It had been a good home, but it wasn't mine anymore, and I was ready to leave it. Celie picked me up at 8 in the morning. We loaded the car with the things I was taking with me. Boxes, suitcases, the essentials. The rest would come later in a moving truck. Celie drove, and I sat in the passenger seat with the window down, feeling the Memphis air one last time. "You ready?" Celie asked as we pulled onto I-24. "I'm ready," I said. We drove east out of Memphis. We left Tennessee behind. By the time we hit Georgia, the landscape had changed. The road stretched ahead of us, long and straight and leading somewhere new. I-16 ran through Georgia, heading toward the coast. Celie had driven this route with me to look at the property I'd found in Savannah. A small house with a porch and a garden and a price tag that I could pay in full with cash. No mortgage, no shared ownership, no one else's name on the deed. Just mine. Celie fell asleep around 2 o'clock. Her head tilted back against the headrest. Her mouth opened slightly. Her hand relaxed in her lap. She'd spent months supporting me through this. standing with me at the courthouse, believing in me when I had to believe in myself, keeping my secrets and standing witness to my victory. Now she was asleep, and that was okay. I could drive. I could get us there. The road rolled out ahead of me. The day was warm. The sky was blue. I had $387,000 in my bank account. I had my dignity. I had my freedom. I had a house waiting for me that belonged to nobody but me. At 4 o'clock, I pulled off the highway and onto the road that led to Savannah. The live oaks hung over the street, their branches dripping with Spanish moss. The light filtered through the leaves, making patterns on the road. The air smelled like salt and growing things. The heat was different here, softer, wetter. The kind of heat that makes you slow down and breathe differently. I pulled up to the address, 412 Forsythia Lane. The house was small, a cottage really, with a front porch and wide windows and a yard where things grew. The property was all mine. I'd closed on it the week before, signing papers as the sole owner, the only name on the deed. The only person responsible for this place. I turned off the engine. The silence was profound. Celie stirred, but didn't wake. I got out of the car. I stood in the driveway, and I looked at the house. This was mine. Not shared with anyone. Not something anyone could take from me. Not something anyone had a claim on. Just mine. I went to the door, and I turned the key in the lock. The door opened. The house smelled like new construction and potential. Sunlight came through the windows and landed on empty hardwood floors. The porch was waiting. The garden was waiting. The life I was going to build here was waiting. I stepped inside and I closed the door behind me. For the first time in my adult life, I was standing in a house that was exactly what I'd chosen. Not a compromise. Not something I'd negotiated or been given or inherited. Something I had earned through work and intelligence and the refusal to let anyone take it from me. I stood there in the empty house and I felt the weight lift. The fight was over. The victory was complete. The future was ahead of me, and I was the only one who got to decide what it would look like. I walked through the rooms, the living room, the kitchen, the bedroom, the bathroom. Every square foot of it was mine. Every decision about what would go where. Every choice about how to live. Every detail about my daily life. It was all mine now. When I came back outside, Celie was awake. She was standing on the porch, looking at the garden, looking at the house, understanding what it meant. "This is it," I said. "This is it," she agreed. We stood there together in the Georgia afternoon, and I understood what it meant to have built something that no one could take from me. Not my children, not their grief, or their debt, or their needs, not anyone's expectation of what I should do or who I should be. Just me and the life I'd chosen, and the woman standing next to me who'd helped me get here. "You want to walk around the property?" Celie asked. "No," I said. "I want to sit on that porch and drink some coffee and tell you thank you." We went back inside and I put water on to boil. I had brought coffee with me, the chicory kind, the real stuff, not the imitation blend. While it brewed, Celie and I sat on the porch and watched the light change as the afternoon moved towards the evening. "Your children know where to find you?" Celie asked. "If they want to," I said. "And if they don't?" "Then I'll know the answer to a question I've been afraid to ask," I said. "I'll know whether they loved me or just loved what I had." Celie nodded. She understood. She'd known enough women in her lifetime to understand the difference. We sat on that porch as the sun moved across the sky. We drank coffee that tasted like home and sounded like the future. And I felt, for the first time since this all began, like I could breathe all the way in and let it all the way out. The house on Magnolia Drive was behind me now. Memphis was behind me. The petition was dismissed. The hearing was over. The victory was complete. What remained was this: a porch, a garden, a door that was mine, and the knowledge that I had built a life that no one else could take away from me. Not my children, not their anger or their need or their grief, not anyone's expectation of what I should be. Just me, finally, standing in a place that was exactly what I chose, with no one else's claim on it. This was what it meant to win. Not triumph, not vindication, not the satisfaction of being right. Just the quiet knowledge that I had protected what mattered most, myself, and that, in doing so, I had earned the right to the life I was about to build. Celie reached over and squeezed my hand. "I'm proud of you," she said. "I know," I said. "I'm proud of me too.